and not come in and say, well, they made me do it for myself, so it's somebody else's fault that I kept drinking. We gave you the tools. We're done. At this, we're done. No, we're done. Mr. Mendoza, turn around. You can say whatever you want, but you're going to face me and you're going to get your sentence. Nobody's saying you went to safety twice. We're saying you went to safety. Hold on, don't listen. I'm going to let you talk, but don't talk over me. You wouldn't have known about anything because you quit going to probation. You were an absconder.
This defendant came to court already in serious trouble after disappearing while on probation. Instead of helping himself, his attitude made things even worse. His response to the probation officer was shocking, and what he later told the judge was just as unbelievable. The judge tried to stay patient, but it was clear this defendant refused to take responsibility. His explanation for the email would only make things worse.
You Anthony Mendoza?
Yes, ma'am.
And Mr. Mendoza was previously in court and entered pleas of true to counts 1 through 13 in a motion to revoke probation. Currently on probation for driving while intoxicated, third or more. That was a 6-year sentence that was probated for 6 years. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, sir. Yes, sir. Yeah.
Are there any additions or corrections to that report?
Nothing to say.
All right, Mr. Parker, you may proceed.
Well, a couple of things I want to address. This situation I see quite a bit where he's ordered to have the scram and interlock. It's costing $600 a month, and he's having to go to work, but yet he's not supposed to drive, and so he's driving with an invalid license, and he's not able to work, and he can't afford to pay for the things he needs to do, such as the 12-step program, the GED program. All those things require money, and that's one of the big issues. But the things I'm concerned about is that it says that he went to the safety relapse program. I'm not sure exactly what happened, but he says he never went to the safety relapse program. I don't know if he was ordered to go and he didn't go, but I think he was in custody at the time, and I'm not sure how that happened. But he also says he's never tested positive for cocaine, which is alleged in here. It addresses an issue that he apparently had with one of the directors of the facility where he became combative. And this also, in turn, is tied to a scram device. He ended up developing a big sore on his ankle, so he would put his sock behind the scram device. And in this incident, he was frustrated, and he wanted to take his boot off to show the director the problem with he had. And that's when they were saying that he was being disruptive. He has no other felonies, Judge. He wants to complete his probation. Like to hear what they say and what happened with that. I'm sure the explanation. And I think you'd also like to address the court.
Well, let me first make sure I've got the timeline, because it appears that I see that safety he completed and then was placed on zero tolerance and the high-medium caseload. After that, there was an issue where he was testing positive, again, for alcohol and cocaine, which I understand he denies the cocaine, but that's what this alleges. And in October of 2022, I'm assuming through an administrative hearing, was granted relapse safety.
Yes, sir. There was a motion to revoke that was all that came before the court, and he was ordered to go to relapse safety. And he absconded.
So he wasn't in custody?
Yeah.
Okay. And then, so we didn't see him again until August 11th of 2023 when he was arrested in Houston. So here's the thing. You probably didn't get any paperwork. Come up here to the front, in the middle here. From at least October of 2022 until August 11th of 2023, you wouldn't have known about anything because you quit going to probation. You were an absconder. And the only reason we found you is because you were arrested in Houston for aggravated assault with a deadly weapon.
Once the judge reviewed the timeline, the defense's argument quickly fell apart. This was a minor violation. He had been gone for nearly a year. Despite that, he acted like he was a victim. The situation became even worse when it was revealed he had been arrested on a more serious charge. The judge simply focused on the facts, showing that he'd been avoiding the system for a long time.
And then in May, we get you back here. You were sanctioned to 180 days in jail. So this is the third time, it looks like to me, that you would have been given an opportunity to remain on probation. Gave you upfront time, continue you on probation. Courtesy supervision was sent to Harris County. And then we have the Scram device issues still, alcohol violations, interlock violations, aggressive behavior, ongoing alcohol use. So if you didn't do the relapse safety, it's not anyone's fault other than your own, because if you didn't know about it, it's because you weren't going to probation. Mr. Nichols?
Judge, I think it's pretty clear. He was put on zero tolerance a couple of years ago, and here we are on the second time.
Third.
Multiple times.
Yeah.
And I don't know what else we could do. So obviously I agree with the probation department's recommendation for revocation. Ms. Martinez, you were supervising, well, Ms. Mendoza was on Harris County, correct? And you are the Jefferson County officer responsible for monitoring. Is that correct?
Yes.
Back in October, when he started having these violations, warnings issued, did you advise him to turn himself in?
Yes.
And what was his response to you?
He had responded with an email that said, "Cop."
That was his own reply to you. Did I ask you to print me out a copy?
Yes.
Showing you what part stakes it. One, for purposes of hearing, is this a copy of the email? What is applied to you? To the it's turning him to the court for purposes of this hearing now for stakes to
It's admitted.
and is that pretty consistent of his level of cooperation that's probation wise?
Yes.
No question, Your Honor.
Any questions?
Just a couple. I want to clarify on the relapse program. You said he was in, y'all came to court on motion revoked. Is that my understanding?
Yes.
And so the safety relapse was ordered by Judge Wicks.
Yes.
And he was here. The defendant was here. Mr. Mendoza was here that time.
Okay. Yes.
Well, wouldn't he have been taken into custody?
Yes.
How was this
Okay. It looks like the hearing was completed over the phone. It wasn't my hearing. It was over the phone with the supervisor at that time. Due to him residing in Houston, he reported he had a lack of transportation to report back to the hearing at that time because he had tested positive for alcohol and cocaine. The supervisor had recommended complete relapse safety and issue a warrant for his arrest.
I have no further questions for her, Judge.
Right, anything
I have
else?
other questions for Ms. Martinez.
Thank you, Ms. Martinez.
I think he wanted to address the court, but we never did because
Sure.
we talked with her.
Go ahead.
I'd like to tell the court.
You're saying I went to safety twice. I mean, it went.
Nobody's saying you went to safety twice. We're saying you went to safety. Hold on, don't listen. I'm going to let you talk, but don't talk over me. We're saying that you went to SafeP and then that you were ordered to go to the SafeP relapse, but you never came and turned yourself in after that phone call where you were told that there was to be a warrant for your arrest. So no, you never went to SafeP relapse. Go ahead.
She said I was supposed to tell myself in. That was after this denied violence that after 3 years so I dropped to misdemeanors terrorist. But so when I was here, y'all let me out. I was trying to work, and they kept saying there was yes, I'm with the scam device.
Okay.
So I was actually at work, and she said, "This it's my fault." I was trying to work and trying to pay, for the devices and stuff, since they were violating me for the operating my truck without for permissions. So that's when I just did the terms.
Right. So did you respond? That's what you thought about all that?
Yes, ma'am. They did actually say that.
You thought that was funny?
It's because I was agitated and I was taking lunch at work.
When he tried to explain the email, his excuse made little sense. The message sounded disrespectful and showed a lack of concern for the probation officer's warning. Instead of accepting responsibility, he claimed his words were misunderstood. However, the court wasn't convinced, and his explanation only created more problems for him.
And I was trying to make money to take the classes, but with being on the money.
Well, you had money to buy alcohol. You had, because you kept drinking, because you kept messing. I mean, Mr. Mendoza, you have been given so many opportunities on this probation, and I understand that those things are expensive. However, if you had at any time stopped testing positive and having blood alcohol readings that were positive on those things, then you could have eventually gotten off of those. I don't keep people on those for very long. But the reason we had to keep doing it for you is because you kept drinking. You kept messing up. And so you don't get to say, I kept messing up. I mean, seriously, you got the initial probation in 2021. You got relapse. I mean, you got safe P. You got some upfront time because of the Harris County issue. Didn't revoke you. Haven't revoked you 3 times. Haven't revoked you. And here we are with all of these violations.
In your TVCJ program, I was doing there. The only time I had issues when I had those thought problems, I got hit the halfway house. That's the only reason they said I was gone from the TVCJ program.
Okay.
I'm actually done well through the program, through with the supervisor division. The only time I messed up is when they stopped supervising me and made me go doing these things by myself.
Well, I mean, how old are you?
43.
43 years old.
And I have no felonies on my record except for this.
That doesn't mean anything. You have this felony and you have 6 years hanging over your head. And you've been given all the tools. You went to SafeP. You got aftercare. At some point, you have to take those tools and do for yourself and not come in and say, well, they made me do it for myself, so it's somebody else's fault that I kept drinking. We gave you the tools.
If I can
We're done. At this, we're done. No, we're done. Mr. Mendoza, turn around. You can say whatever you want, but you're going to face me and you're going to get your sentence. And if at this time I could give you more, I would, I promise you, but I can't. So I'm going to find that you entered your pleas of true to counts 1 through 13 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time revoke your probation. Sentence you to 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you a certification of your right to appeal. This was not an agreement. So you do have some rights to appeal. Y'all need to sign that before you leave right now. You need to sign that you're getting a copy of it, and then we'll give you your copy. And then when you're done with that, you can go back with the bailiff.
This hearing was a clear example of someone wasting multiple chances. The court had tried to keep him out of prison, but disappearing for nearly a year made the outcome predictable. Rather than admitting his mistakes, he continued making excuses. In the end, the judge decided enough was enough and imposed a 6-year sentence. Thank you so much for watching, guys. Make sure to like and subscribe, and take care as